Welcome to Episode 9 of Truth and Consequences with Doug Poppa. On December 17, 2019, Las Vegas Justice Court Judge Melanie Andress-Tobiasson testified before the Nevada Commission on Judicial Discipline, as did Las Vegas Justice Court Judge Amy Cellini. Both judges are currently under investigation as of this day, August 29, 2020, and both are still presiding over cases. Shortly, I will read excerpts from the Order Continuing Commission Investigations that was filed by the Nevada Commission on Judicial Discipline on December 24, 2019, that explains the allegations against both judges. During Judge Tobiasson's testimony on December 17, 2019, Judge Tobiasson appeared unsure of the Judicial Code of Conduct, prompting the prosecuting officer for the Judicial Commission to comment, quote, "I can ask whether she's familiar with the code that she said she did not violate. I want to know if she can even tell me what Canon 2 relates to. She shows an utter lack of knowing the code. The code requires that she follow the law, including the code. How can she follow the code if she doesn't even know what it is?" Unquote. Also, during her testimony, Judge Tobiasson stated that she never threatened anyone. The prosecuting officer, Thomas Bradley, then asked Tobiasson if she had given an interview to the Baltimore Post-Examiner. Bradley was referencing my May 2018 on-the-record recorded interview with Judge Tobiasson that I conducted that was published by the Baltimore Post-Examiner in January of 2019. As a matter of fact, several articles that I authored relating to my investigations of both Judge Tobiasson and her involvement in the unsolved 2016 Las Vegas Land Kaufman double homicide that were published by the Baltimore Post-Examiner are attached as exhibits filed with the Supreme Court of Nevada by the Nevada Commission on Judicial Discipline. As I have previously reported, Judge Tobiasson in my interview with her had stated that she threatened Shane Valentine, a Las Vegas pimp, through his attorney. According to Tobiasson, Valentine had attempted to recruit her daughter into prostitution. Tobiasson also stated in that interview that she kicked in the door to Valentine's residence. However, Bradley did not ask Tobiasson about kicking in the door during her testimony in December 2019, but it is documented in court records by the Commission. Tobiasson testified under oath on December 17, 2019, that the interview I did with her in May of 2018 was, quote, "It was a recording of a conversation that was never intended to be published," unquote. Tobiasson said the same thing about the interview she gave KLAS-TV's 8 News Now I-Team in Las Vegas in April of 2018, less than a month before my on-the-record recorded interview with her. Tobiasson told the Judicial Commission's investigator that that interview also was never intended to be published. At the conclusion of my almost 2-hour interview with Judge Tobiasson in May of 2018, I asked her how could I help her, and she responded on the recording that she wanted to get the story out and a lot more. In subsequent emails that I've shown in prior podcasts, Tobiasson said multiple times that she wanted to get the story out, that she knew I had the recording, and that I was going to use it. Here are a few excerpts from my May 2018 interview with Judge Tobiasson. Before we start talking, I have to advise you that the telephone conversation is recorded. You okay with that?
Okay.
Okay. And while we're talking...
Not entirely, but that's okay. I understand why.
Okay. Do you have a problem with me recording the conversation?
It's okay. Go ahead.
Give me your name. Can you state your name and then your position in Clark County?
Can I ask you what purpose your recording will be used for?
Well, the recording is for your protection and it's my protection because what I believe...
You don't,
Go ahead.
You don't plan on using it, though?
Well, of course I'm going to use what you tell me if I end up doing a story, which I don't know if I'm going
I
to.
understand that. Not the actual recording, though.
No, am I going to use your recording in my story?
Yeah.
No, I'm going to use what you tell me. If I listen,
Thank you.
If I end up...
I don't mean to be difficult. I'm just saying, you know.
Okay, if I end up doing a story after we talk, I'm going to use what you tell me in the recording as a basis for my story.
Gotcha. So I contact Shane Valentine's attorney. It's about July now of 2016. And because I know that the cops at this point aren't going to do anything. I called his attorney and I said, hey, you might want to get your client a message that if he calls my daughter again, I'm going to take care of it myself. So he does. He gives him the message. That's, we don't really want to report that.
Are you married to a Metro cop?
He's retired, and no, he didn't help me.
He's not helping you?
He hasn't helped me through any of this. I was the one who went to Shane Valentine's house, kicking the door.
What do you want me to do? How can I help you?
I mean, I'd love to get this story. There's a lot more.
Shortly, I will play video excerpts from Judge Tobiasson's testimony on December 17, 2019. The Nevada organization, Our Nevada Judges, video recorded all the testimony from the two-day hearing. It is available for viewing free of charge on the YouTube channel of Our Nevada Judges. Excerpts from the Order Continuing Commission Investigations is as follows. The full document can be read on the screenshots in this podcast. Pursuant to prior written notice, the above entitled matter was set for a two-day consolidated public interim suspension hearing before the Nevada Commission on Judicial Discipline, commencing on December 16, 2019 in Las Vegas, Nevada. Thomas C. Bradley, Esquire, and Brian R. Hutchins, Esquire, served as the prosecuting officers to the Commission and were present. Judge Tobiasson was represented by William B. Terry, Esquire, and Judge Cellini was represented by Thomas F. Pataro, Esquire, all of whom were present. During the hearing, the Commission considered all evidence and testimony presented. At its meeting on May 31, 2019, the Commission unanimously authorized the Executive Director of the Commission to file complaints against Judges Tobiasson and Cellini based on objectively verifiable evidence from which a reasonable inference could be drawn that Tobiasson and Cellini were abusing the prestige of their respective offices, interfering in human resource matters pertaining to the assignment and discipline of court clerks, creating a hostile work environment for Las Vegas Justice Court administration and staff, as well as various other allegations of misconduct. The Commission authorized a thorough investigation into these matters. On October 18, 2019, the Commission unanimously decided to suspend the respondents with the pay pursuant to Nevada Revised Statute 1.4675 based on the results of the Commission's investigation, which revealed evidence of Justice Court administrators and others being bullied, harassed, threatened, and intimidated by Judges Tobiasson and Cellini, thereby creating a hostile work environment. The Justice Court's Administrator, Justice Court Division Administrator, and the Justice Court Clerk Supervisor being terminated allegedly in retaliation for either informing the Chief Judge of issues involving Judges Tobiasson and Cellini or for cooperating with the Commission's investigations of both judges. Other current Justice Court employees being retaliated against for allegedly either filing a complaint with the Commission and or cooperating with the Commission's investigations of both judges. Justice Court administrators and supervisors being routinely addressed as, quote, unquote, motherfuckers and fucking bitches by Judges Tobiasson and Cellini during the working hours and toward and around employees. Judge Tobiasson on more than one occasion wearing a sweater inside and around the Justice Court that reads, quote, unquote, eat shit and die. The Justice Court's daily operations in servicing the public being plagued by strife and internal conflict by virtue of the practice of quote-unquote blacklisting and quote-unquote reverse blacklisting court clerks by Tobiasson and Cellini and others. Blacklisting refers to the practice of judges restricting certain clerks from working in their judicial departments, while reverse blacklisting refers to the practice of judges restricting certain clerks from working in other judicial departments. The evidentiary record supported that Judge Tobiasson allegedly ordered 2 female clerks who filed complaints against Judge Tobiasson's male court clerk for improper behavior toward them to not be assigned to her court. The evidentiary record further demonstrated that if anyone filed a complaint against Judge Cellini's court clerk for improper behavior toward them, Cellini would allegedly quote-unquote blacklist them and not permit them in her courtroom. Tobiasson and Cellini's interference in Justice Court Administration's court clerk assignments, as well as in disciplinary investigations and actions involving their respective court clerks. Moreover, even the current Justice Court Administrator, Grizel Hernandez, characterized the Las Vegas Justice Court as a quote-unquote mess and a quote-unquote shit show across the board due to lack of leadership and supervision. In their respective commission investigative interviews, several witnesses stated that they and others were scared of Judges Tobiasson and Cellini and in fear of losing their jobs. One witness even expressed a fear of her physical safety based on statements made by Judge Tobiasson that she, Judge Tobiasson, knows a lot of people in town and that they, quote-unquote, take care of things. This witness perceived Judge Tobiasson's statements to be veiled threats of what Tobiasson could do to her if she, the witness, did not comply with Tobiasson's demands. Based on its detailed review of the evidentiary record at the time, including investigation reports submitted by the Commission's investigator, along with multiple supporting exhibits and witness interviews and related transcripts, the Commission decided to suspend Judges Tobiasson and Cellini with pay pursuant to NRS 1.4675. On November 5, 2019, Tobiasson and Cellini filed a response to Notice of Commission's intent to suspend with salary, wherein both chose not to waive their respective rights to a public hearing before being suspended by the Commission. A consolidated public hearing was scheduled for December 16 and 17, 2019, at the William S. Boyd School of Law, Thomas and Mack Moot Court Facility in Las Vegas, Nevada. At the public hearing, the Commission considered over 1,211 pages of exhibits and the sworn testimony of 10 witnesses. In exercising its discretion, as conferred on the Commission pursuant to Article 6 of the Nevada Constitution, the Commission has decided to not take action against Judges Tobiasson and Cellini at this time. The Commission's investigations against both judges shall continue in accordance with Nevada law until such time that the Commission decides, if at all, to file a formal statement of charges against Judges Tobiasson and Cellini. They are ordered to fully cooperate with the Commission's ongoing investigations against them. The Commission also reminds Clark County that they have a legal obligation to comply with constitutionally authorized subpoenas duces tecum issued by the Commission in connection with these matters. To date, Clark County has rejected and is currently refusing to comply with certain subpoenas duces tecum issued by the Commission, the effect of which is obstructing the Commission's investigations against both judges, thereby delaying the receipt of critical documents and information needed by the Commission to further proceed in the investigatory phase of the judicial discipline process. If Clark County continues to reject the Commission's lawfully issued subpoenas duces tecum, the Commission will be forced to hold Clark County in contempt of court and impose a penalty to enforce the subpoenas. If Clark County continues to refuse to comply, the Commission shall then follow the procedures set forth in the Nevada Revised Statutes before the Clark County District Court to address Clark County's continued noncompliance. If the Commission decided to suspend the judges at this time, Nevada Revised Statute 1.4675 requires that the prosecuting officers file formal statement of charges against them within just 60 days. Not only does much more evidence remain to be gathered and analyzed, but the 60-day rule would inhibit the Commission from continuing its thorough investigations. The Commission has decided to forego the expediency of suspending Judges Tobiasson and Cellini at this time in favor of continuing its investigations, particularly in light of the anticipated delays associated with Clark County's ongoing refusal to comply with the Commission's subpoenas duces tecum, as well as the existence of additional information and evidence received by the Commission and during the hearing, which are currently being investigated and followed up on by the Commission. Moreover, based on testimony during the hearing by Judges Tobiasson and Cellini and certain witnesses, the Commission feels compelled to point out that not one Las Vegas Justice Court judge who testified on behalf of Tobiasson and Cellini could bring themselves to admit that routine utterances of subjudicial standard profanity inside the Las Vegas Justice Center during work hours and toward and around employees, and the wearing of clothing inside and around the Las Vegas Justice Court containing vulgar statements were inappropriate or a violation of the Code of Judicial Conduct. Finally, in case the meaning of judicial integrity, honor, respect, and dignity are in doubt, the Commission, Tobiasson and Cellini and respective counsel, as well as other members of the judiciary, the press, and the public, should be mindful of what is stated in the preamble to the Code of Judicial Conduct as follows. The United States legal system is based upon the principle that an independent, impartial, and competent judiciary composed of men and women of integrity will interpret and apply the law that governs our society. Thus, the judiciary plays a central role in preserving the principles of justice and the rule of law. Inherent in all the rules contained in this code are the precepts that judges, individually and collectively, must respect and honor the judicial office as a public trust and strive to maintain and enhance confidence in the legal system. Judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. They should aspire at all times to conduct themselves that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. The Code of Judicial Conduct establishes standards for the ethical conduct of judges and judicial candidates. It is not intended as an exhaustive guide for the conduct of judges and judicial candidates who are governed in their judicial and personal conduct by general ethical standards as well as by the Code. The Code is intended, however, to provide guidance and assist judges in maintaining the highest standards of judicial and personal conduct, and to provide a basis for regulating their conduct through disciplinary agencies. It is further ordered pursuant to Code Rule 2.16 that no person known or suspected to have assisted or cooperated with an investigation of a judge shall be retaliated against directly or indirectly. Now, here are video excerpts from Las Vegas Justice Court Judge Melanie Andress-Tobiasson's testimony before the Nevada Commission on Judicial Discipline on December 17, 2019, courtesy of our Nevada judges. Pay close attention to Judge Tobiasson's testimony where she says she never threatened anyone. At the conclusion of the video, I will have some closing comments for this podcast.
Please face me, raise your right hand to be sworn. Do you solemnly swear in the testimony providing this matter is the truth, the whole truth, and nothing but the truth, so help you God? Go ahead and have a seat there. Go close to the microphone there, state your name, spell your first and last name for the record.
Melanie Andress-Tobiasson, M-E-L-A-N-I-E, Andress, A-N-D-R-E-S-S Tobiasson.
Thank you. Go ahead, Mr. Pratt.
Judge, are you familiar with the Nevada Judicial Code?
Yes.
And can you tell us the difference between the judicial canons and the judicial rules?
I'm not sure I can define those distinctly separately. I mean, the canons clearly are directives or rules that we must follow in terms of our ethical obligations and guidelines. Rules are simply rules that we must follow in the course of conducting our business as judges.
How many canons are there?
Unfortunately, I don't know the exact number.
And I'm going to object. Relevancy. What has this got to do with this? I mean, how many commandments are there? How many commandments are there in the Constitution?
The judges are denying that they did not violate the code. I want to explore whether or not they know what the code is.
Well, I don't have it memorized.
I'm going to prevent the question. Go ahead, why don't you start it, Mr. Pratt.
So do you know what canon 1 provides?
I mean, is there a directive that I can look at the canons? I mean, I do not have the canons memorized.
Okay, I understand that. You don't have any idea what canon 1 says, correct?
Not from memory now.
Well, let me help you.
Okay.
Canon 1 provides in part that a judge must observe high standards of conduct, so the integrity of the judiciary must be preserved. Okay? So tell the commission how you would define integrity.
Well, integrity is a lot of things. It can include truthfulness, conducting yourself in a way that is in a manner that is honest and honorable and truthful.
And how would you define impropriety?
Well, there's a multitude of ways you could define impropriety.
How does the code define impropriety?
I'm not sure what the exact definition of the code is. I mean, if you want to give me a copy of the code, I'd be happy to refer to it.
Would you agree that impropriety includes conduct that undermines a judge's integrity?
I guess on a general basis it could.
And do you know what rules apply to Canon 1?
Not from memory.
Are you familiar with Rule 1.1 that says a judge shall comply with the law, including the Code of Judicial Conduct?
Yes.
And are you familiar with Rule 1.2 that says in part, a judge shall act at all times in a manner that promotes public confidence in the integrity of the judiciary?
Yes.
And what do those rules mean to you?
Well, they're extremely broad, but a judge acting at all times in a manner that promotes confidence in the judiciary is conducting your job and your professional actions in a way that promotes public confidence and also promotes the administration of justice.
And we can agree that that public confidence is not just what happens in the courtroom, but what happens outside the courtroom, correct?
I guess in certain circumstances.
What's that?
I believe in certain circumstances, yes.
What circumstances would a judge's conduct outside the courtroom not apply? When would the code not apply?
Well, I think at some point it's forgotten that judges are actually human beings who have a life outside of their job and engage with people in ways that have nothing to do with their job or these directives.
Would you agree with the following statement that a judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code?
It's quite apparent that that's...
What's that?
I said it's quite apparent that that's the case.
And you agree with that? That's fair.
Well, under certain circumstances it's fair. Under certain circumstances, I think it's not necessarily fair.
Can you cite any cases or rules or commentary that would suggest that there's any limitation to this
Well, I
statement?
mean, there's certain situations where, just like in any circumstance, there are judges who are looked at for everything they do, no matter what it is or what people say it is, and there are those who aren't. So I don't think it's applied across the board.
Are you suggesting that this commission is looking at you
I'm not
differently than
suggesting
other
anything
judges?
at all about this commission.
What's that?
I'm not suggesting anything at all about this commission.
Can we agree that conduct that compromises or appears to compromise the integrity of a judge undermines public confidence in the judiciary?
I'm sorry, I'm not exactly sure I know what the question was.
I'll read it again.
Thank you.
can we agree that conduct that compromises or appears to compromise the integrity of a judge undermines public confidence in the judiciary?
Again, it's very broad. Sure, I think there are things that could. I also think that there are things that can be alleged that, if true, absolutely could.
Are you aware?
Your allegations don't necessarily mean that that in fact has happened.
So Judge, I asked if you knew the difference between canons and rules. Are you aware that the Judicial Code also has something called a commentary?
I've read the entire thing at some point, but
What I just read you was a comment, was one of the comments to the rules, so you're not familiar with that comment?
well, you asked me if I agreed with that statement.
Right. And now I'm asking you
It's
to be
very
familiar.
general.
And, I'm sorry, go ahead.
No, go ahead.
So now I'm asking you, you seem to be unsure about whether that statement is
I
correct.
didn't say I was unsure. I said, of course, it could be correct under certain circumstances. I think it's very broad, and to just say that that is,
Would it be fair to say you didn't recognize it as one of the comments in the code?
well, I can assure you that I don't have the comments memorized.
So is it important, I mean, when you first got your complaint, there were a number of code sections listed, right, about what this commission thought you may have done wrong, or at least what the complainants thought you did wrong, right?
Yes.
And then you had a notice of suspension. You knew about that,
Of
right?
course I did.
And then I'm assuming you read my pre-hearing brief,
I sure did.
and I cited a bunch of rules in there, didn't I?
Yes, you did.
Okay. So what I'm talking to you about were all these things that have been in your life recently. And it doesn't appear to me, at least, wait, I'll withdraw that comment. So tell me what Canon 2 is.
Well, I'd be happy.
Can I object to the form of the question? We can relate it to what we're doing here today and what the allegations are. There are things that are in Canon 2, for example, that have nothing to do with this hearing.
I can ask whether she's familiar with the code that she says she did not violate. I want to know if she can even tell me what Canon 2 relates to. It shows an utter lack of knowing the code. The code requires that she follow the law, including the code. How can she follow the code if she doesn't even know what it is?
I'm going to permit Mr. Bradley to form the questions as he sees fit. Go ahead, Mr. Bradley.
Well, I have notebooks and boxes full of documentation over there. I can tell you that I have not memorized the code. I cannot tell you, sitting here, and define to you what the entire code says without it sitting in front of me. If I could, I'd be happy to take a copy of it.
There's four canons, and so far you can't tell me what any of them said, correct?
Not from memory.
Well, let me see if I can help you. Canon 2 says a judge shall perform the duties of judicial office impartially, competently, and diligently. Okay? So and you were perhaps not formally charged, but put on notice that you violated several rules that fall within Canon 2. Can you tell me what any of those rules say?
Not
Object to the form of the question related to what we're doing here today.
So you were one of the rules that you were that was indicated you may have violated is Rule 2.3b. Are you familiar with that one?
I'm not by memory.
So again, let me see if I can help you. Rule 2.3b in part provides the judge shall not, in the performance of judicial duties, by words or conduct, engage in harassment. You familiar with that rule?
I am.
And can we agree that's an important rule that should be strictly enforced by this commission?
Of course.
And are you familiar with Rule 2.5a, which provides in part that a judge shall perform administrative duties competently?
Yes.
And we can also agree that this commission should strictly enforce that rule.
I don't know. I can't impose anything on this commission, it's an important rule.
Are you familiar with 2.5b, which provides in part that the judge shall cooperate with court officials in the administration of court business?
Yes,
Again, another important rule which should be enforced.
they're all important.
Who does that apply to? Who do you have to be under the rule? As you sit there today, who do you think you have to be patient, dignified, and courteous?
I think it's important to be that way with all people.
Who are you required to be patient, dignified, and courteous to under the rules?
Well, attorneys that appear in front of you, defendants that appear in front of you, parties that appear in front of you, and people that you work with.
Do you think a judge who arrives in the courthouse and says to the court employees, "Hey bitches, I'm here," if a judge did that, can we agree that would be a violation of the rule that a judge act in a manner that promotes public confidence in the integrity of the judiciary?
If it were true, I suppose you could make that argument.
I'm not asking you whether it's true, I'm asking you to assume that if the judge does that, you can agree that that would be a violation of the rules,
I
correct?
can't agree it would be a violation. I can agree that it could appear to be a violation.
And again, I'd like you to assume that a judge calls up a court administrator and greets her with the phrase, "What's up, mother, F-U-C-K-E-R." I'd like you to assume that happens. Can we agree that if a judge did that, that would violate the rule to act at all times in a manner that promotes public confidence in the integrity of the judiciary?
I don't necessarily think saying something, even if it involves language, would be a violation depending on the content in which it was stated. And I certainly wouldn't have had any personal information or personal knowledge or exposure to this.
Where do you think the use of profanity is permissible by judges at a courthouse, and where do you draw the line and say it's not permissible?
That's a loaded question, but I mean, the use of profanity is fairly common. Certainly, I don't think it is appropriate to be directed at somebody in a hostile way or to be directed at somebody in the courtroom environment. I don't know exactly where the line would be drawn.
So are you saying that it's okay for a judge to use profanity such as the F word or bitch or mother, F-U-C-K-E-R, as long as it's not in the courtroom?
No, I did not say that. I said if it were to be directed at somebody or used in a way that would be something other than just using it in the normal course of talk.
So using Mr. Terry's example, it's okay to say mother, F-U-C-K-E-R, as long as I don't say you're a mother, F-U-C-K-E-R.
Not in every circumstance, no.
Do you think that the common use, the routine use of profanity around court staff is permissible?
Common as in constant? No.
Routine, daily.
Well,
If daily you use the F word, is that appropriate or inappropriate?
under what circumstances?
You're outside talking to staff, you're not directing the F word at somebody, you're just saying, I had an effing day here, or this effing thing happened, or I'm so effing mad at something else. Isn't that completely beneath your position as a judge?
I guess it would depend on the circumstances.
So the use of profanity doesn't denigrate the office?
I guess I'm not as offended by the use of some profanity as apparently others are.
Well, let's talk about your sweater. You have a sweater that says, "Eat shit and die," correct?
Correct.
And you wore it to the courthouse more than once, correct?
No,
So,
I know it's been stated I wore it more than once.
so was it okay to wear it once?
Well, I wore it.
No. Was it beneath the dignity of your office to wear a sweater to the courthouse to be seen by court staff that says, "Eat shit and die"? Is that appropriate?
I can see how it would be viewed as inappropriate. I did not feel it was because of the way it is hidden in the shirt.
So the fact that it wasn't in
Would I do it again?
the fact that it wasn't in bold language made it okay, but the fact that it was a little harder to see makes it fine? Is that what you're saying?
I'm saying I did not view it as denigrating the dignity.
You don't see a problem with that?
I did not.
Now, yes or no, did you tell the investigator there's no such thing as a blacklist?
I did.
You did say that,
I
correct?
did say that.
Okay. All right. And you told the investigator that you never referred to Ms. Coda as a effing bitch, correct?
Absolutely said that.
And by effing, I mean you
I know what you
actually,
mean.
you actually used the entire word.
I actually didn't.
All right. In fact, you said you were astonished by an allegation that you would call her a effing bitch, correct?
I was astonished by the allegation that I did call her that.
Now, is that because you don't usually use profanity?
That's because I never said that about her,
So
or to her, or in her presence, or outside her presence.
we can agree that you do use the F word commonly?
I don't know how you define commonly, I have used the
Routinely.
F word, I have cussed.
You have
I
routinely used the
acknowledge
F word.
that in my statement.
What's that?
I acknowledge that in my statement, I cussed.
All right. And so you use the F word, you've used the word bitch, correct?
I've cussed,
Right? Is that a yes?
yes.
All right. So is it that you're denying that you use them in conjunction? You say F
I
and
didn't
you
say
say
I
T,
denied
but you
using
don't
them in
say F and
conjunction.
T?
I denied saying that to Elizabeth Cook.
But you have called people an F and bitch before, correct? In this courthouse, have you ever used the term F and bitch?
I don't know, I can't think of a specific time, but I can assure you I didn't use it directed at or on that day.
Okay, so when Ms. Coda got up on the stand and swore to tell the truth, she lied to this commission,
She
correct?
did,
All right.
or she made a serious mistake, but I can assure you I did not call her that day.
Okay. And you denied saying, "Here I am, effing bitches," when you come to work, correct?
Yeah, I don't have a recollection.
And you said, in fact, you told the investigator, "I don't recall saying that."
I did say that, I just said the same thing, I don't have a
So-
recollection of saying that.
But if you had a practice of arriving and saying, "Here I am, effing bitches," you'd be more likely to remember it.
Yeah,
So, but we can agree that a judge who announces her arrival by saying, "Here I am, effing bitches," that's offensive, isn't it?
yeah, if I did that every day, I sure think it would be offensive.
Morally offensive, right?
Well, I don't know about morally offensive, but it would be offensive. Or at least would be inappropriate, I don't know.
What's your distinction you're drawing between offensive and morally offensive?
Well, I don't know if it's immoral.
Not immoral to,
There's a distinction. I mean, some people think some things are immoral that other people don't.
do you think it's morally offensive to say, "I'm here, effing bitches"?
To some people it may be, but
To you?
I don't think it would morally offend me if somebody said that.
But you just can't recall whether you said it.
I don't have a recollection of saying that. Initially, she said that she heard, somebody told her that I said that, and then on the stand, she said that she personally heard it, so.
In the interview, you said that I have never threatened somebody with my husband or the people I know, correct?
Correct.
And you said that's offensive.
Correct. To be accused of that?
And you told the investigator the allegations that you threatened people is completely out of the realm of comprehension. Do you recall that?
Yes, I do.
Because I would never engage in that kind of behavior. That's what you told him, correct?
Correct.
But that's not true, is it? In fact, you have bragged about threatening people, haven't you?
No.
Did you give an interview to the Baltimore Post-Examiner in 2018? She denies she ever threatened someone. She admits that she threatened someone in a newspaper article, and there's an audio recording of it.
I'm not permitting this. Go ahead.
Did you give an interview to the Baltimore Post-Examiner in 2018?
Very unfortunately, yes.
And they recorded the interview, correct?
It was a recording of a conversation. It was never intended to be published.
Kim Gambling said that she was threatened by Judge Tobiasson. Judge Tobiasson said that she's never threatened anybody. I have the right to impeach her statement based on her own words. It's completely relevant to this case. Did you tell the Baltimore Post-Examiner that you were trying to prevent an individual from contacting a member of your family? So you called his attorney and said, quote, hey, you might want to get your client a message that if he calls my family member again, I'm going to take care of it myself.
I know that's what I said, and I also know that I was in a position where I had begged for help and gotten none. Not only have I not gotten help, but I later learned.
So you admit you made the statement. I'm not asking you what. I'm not
Hold
asking you
on
why.
a second. Please don't speak over each other.
I did not threaten a person directly.
You threatened through his
This
attorney.
person was continuing to contact a member of my family on a day that
Excuse me, if you're going to open the door to a bunch of questions about why this happened, then I get a follow-up. So I would suggest that you answer my question, which is, did you make that threat, yes or no?
it wasn't a threat.
Okay.
As I have reported in previous podcasts that are available on the Truth and Consequences with Doug Poppa YouTube channel and Facebook page, Las Vegas Justice Court Judge Melanie Andress-Tobiasson is also under investigation, separately and apart from the one discussed in this podcast. That investigation, according to court records, involves a complaint that was filed against Tobiasson by Connie Land, whose daughter Sydney was one of the victims in the now almost 4-year unsolved 2016 Las Vegas Land-Kaufman double homicide. Judge Tobiasson, as I have previously reported, befriended Connie Land after her daughter's murder, and a bizarre series of events relating to Judge Tobiasson's conduct with Mrs. Land led to that complaint. Court records state that the investigation also involves Judge Tobiasson's admissions of judicial misconduct, which the judge disclosed in various interviews with news reporters. In addition, the Nevada Commission on Judicial Discipline in court records asserts that, by including in its pleading allegations of criminal conduct by Judge Tobiasson, including involvement in purported murder plots. In upcoming podcasts, I will have more information on Judge Tobiasson and the unsolved Land-Kaufman murders, including a statement that was made by Judge Tobiasson that conflicts with what she told me about why she believed the Land-Kaufman murders happened. Keep in mind that the Las Vegas Metropolitan Police Department to this day have not refuted Judge Tobiasson's on-the-record claim to me in May of 2018 that homicide detective Jared Grimmett released confidential details about the double homicide investigation to Tobiasson, or Judge Tobiasson's allegations that Detective Grimmett told her that the police had all the evidence that indicated Shane Valentine, Dominique Thompson, and Frankie Zapier were involved in the murders. Almost 4 years later, nobody's been charged in the murders. Thank you for listening.